Trump's bail just completely collapsed. Judge Arthur Engoron made it absolutely clear during a closed-door emergency hearing on Thursday, January 23rd, that Donald Trump has exactly zero pathways left to avoid posting the full $464 million bond in the New York fraud case. Sources inside the courtroom reveal the judge used the word final 3 separate times when rejecting Trump's legal team's latest desperate attempts to delay or reduce the amount. This isn't some minor procedural setback or a temporary obstacle. This is the precise moment when every single escape route got systematically dismantled by a judge who has, quite simply, run out of patience for delay tactics. When a sitting federal judge tells your attorneys that the words "no further extensions" mean exactly what they say, you know the walls have finally, truly closed in. Hit that subscribe button right now because you won't want to miss any of the videos I release as this story unfolds. So, what exactly set off this extraordinary judicial smackdown? Trump's legal team reportedly filed what sources describe as their 7th motion in just 3 weeks, attempting to either reduce the bond amount, delay the deadline, or allow alternative forms of security. The judge's response, according to multiple attorneys present in the courtroom, was unusually blunt and left absolutely no room for interpretation. He stated that Trump had been given multiple opportunities to secure financing, that the appeals court had already ruled on the bond amount, and that any further delay requests would be viewed as obstruction. This isn't just another legal dispute or routine courtroom drama. Multiple legal analysts are saying this represents the judge signaling that the endgame has officially arrived. And believe me, when federal judges start using phrases like, "the court's patience has been exhausted," you know something enormous has just detonated. Here's the full, unvarnished picture of what's been unfolding. Tensions between Judge Engoron and Trump's legal team have been steadily building since the massive $464 million judgment was handed down on February 16, 2024. That ruling, as you'll recall, found Trump guilty of fraudulently inflating asset values by billions of dollars to secure better loan terms. But everything escalated dramatically on January 18th, when Trump's attorneys filed yet another emergency motion, claiming that no bonding company would accept real estate as collateral. Judge Engoron's response in the January 23rd hearing was absolutely devastating. He pointed out quite directly that Trump had publicly claimed to have over $400 million in cash just weeks earlier during his campaign rallies. The judge stated that Trump's team was essentially asking the court to accept that their client had either been lying to voters about his wealth or was lying to the court about his inability to post bond. Smash that like button if this is making sense so far. Here's where it really gets serious. When Judge Engoron reviewed the latest financial disclosures submitted by Trump's team, he reportedly recognized immediately that the numbers simply didn't add up. Court sources say the judge spent nearly 12 minutes methodically comparing statements Trump made publicly about his liquid assets versus the claims being made in court filings. And let's be honest for a moment, demands for full bond amounts without any reduction are extremely rare in civil fraud cases of this magnitude. They don't happen over minor inconsistencies or technical violations. They happen when judges genuinely believe a defendant has systematically attempted to manipulate the process and is highly unlikely to comply voluntarily with any judgment. Here's what multiple sources familiar with the hearing say happened next. On January 23rd, a closed-door conference was held in Judge Engoron's chambers with lead attorneys from both sides present. Trump's legal team presented what they characterized as their final effort to secure modified bond terms, including letters from 4 bonding companies stating they would not accept real estate as collateral. Sources told CNN that Judge Engoron listened to the 20-minute presentation without interruption. Then came his response. According to 2 attorneys present, the judge stated, "I have reviewed these letters. I have also reviewed your client's public statements about his cash reserves and his overall net worth. These positions are irreconcilable." Christopher Kise reportedly attempted to interject, but Judge Engoron cut him off, stating, "Counselor, your client has options. Sell assets. Secure different financing. What your client cannot do is claim wealth when it benefits him politically while simultaneously claiming poverty when financial obligations come due." Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely explosive. The moment Judge Engoron finished that statement, Trump's lead attorney, Alina Habba, reportedly stood and requested a brief recess to consult with her client. The judge denied the request. He stated that the court had provided more than adequate time for the defense to prepare alternatives and that the conference would proceed. What happened next was described by attorneys present as virtually unprecedented in New York civil litigation. Judge Engoron laid out a timeline with specific dates and specific unavoidable consequences. He stated that Trump had until 5 p.m. Eastern Time on Monday, January 27th, to post the full bond amount or provide proof of an irrevocable agreement with a bonding company for the full $464 million. If that deadline passed without compliance, the New York Attorney General's office would be authorized to immediately begin enforcement proceedings. That means asset seizures, property liens, and potential freezing of bank accounts. The judge made it crystal clear there would be no further extensions, no additional motions for reconsideration, and no emergency appeals that would halt enforcement. This move sent shockwaves through the legal community and Republican political circles. When a judge with Judge Engoron's reputation for procedural caution starts imposing hard deadlines with immediate enforcement consequences, it signals that the normal give and take of civil litigation has ended. Legal experts noted that the judge's language eliminated any ambiguity. The claims that this is political persecution or partisan overreach simply collapse when you look at the actual record. Trump's team has filed 7 motions in 3 weeks. The judge has reviewed financial disclosures, bonding company letters, public statements, and campaign finance reports. The pattern he identified wasn't bias, it was blatant contradiction. This isn't the first time a prominent defendant has faced this type of judicial ultimatum over bond requirements. Think back to Bernie Madoff in 2009. After his arrest, Madoff's attorneys argued he should be released on bonds secured by his Manhattan penthouse. The judge rejected the motion, stating that Madoff had demonstrated a pattern of deception. The key similarity is the judge's focus on credibility. When a defendant's public statements contradict court filings, judges view it as undeniable evidence of ongoing deception. Then there was the Enron situation in 2004. Jeffrey Skilling attempted to use company stock as collateral. The court rejected it, noting that the fraud charges involved inflating that very stock's value. The parallel is clear. If your alleged fraud involves misrepresenting asset values, courts are inherently skeptical of accepting those same assets as bond collateral. Subscribe immediately if you haven't yet. And let's not forget Trump's own previous bond issues in the E. Jean Carroll defamation case. Initially, his team argued they couldn't secure the $5 million bond quickly. Then, when the judge set a firm deadline, the bond miraculously appeared within 48 hours. That pattern of claiming impossibility followed by sudden compliance has clearly influenced Judge Engoron's current approach. Now, however, the stakes are exponentially higher. We're not talking about $5 million, we're talking about a staggering $464 million, and this time the judge has made it clear he's not playing the same game. The pattern couldn't be clearer. When defendants claim financial inability while simultaneously projecting vast wealth, judges eventually reach a breaking point where further accommodations simply end. So what allegedly triggered this unprecedented judicial response? According to legal analysts, Judge Engoron's decision was driven by a fundamental credibility gap. Trump's attorneys claimed posting a bond of this magnitude was essentially impossible without using real estate. They cited industry standards requiring approximately $557 million in liquid securities for a $464 million bond. Here's the kicker. Just 17 days before filing that motion, Trump appeared at a rally in Manchester, New Hampshire, where he stated, "I have almost $500 million in cash sitting in accounts right now." The New York Attorney General submitted that video clip as evidence. This wasn't a policy disagreement. It was a direct, undeniable factual contradiction between public statements and court filings submitted under penalty of perjury. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone watching this case. This isn't just about one bond motion or one hearing. If defendants can make contradictory claims about their financial status, depending on whether they're courting voters or facing legal obligations, the entire civil justice system loses its foundation. Once courts determine they cannot rely on financial disclosures because defendants treat different forms with different levels of honesty, the precedent becomes that only the most aggressive enforcement measures are viable. At that point, there's no going back to trust-based negotiations or voluntary compliance. This puts Trump in a nearly impossible position. On one side, he faces enormous political pressure to maintain the image of vast wealth. His entire brand, his campaign messaging, and his appeal to voters depend on the perception that he's a uniquely successful businessman. Admitting he cannot access $464 million directly contradicts that fundamental narrative. That means he's incentivized to keep claiming substantial liquid wealth publicly. On the other side, he's forced to reckon with actual legal obligations that require turning turning those claims into reality. He now has to explain to his political base why, if he truly has nearly $500 million in accessible cash, he's fighting so hard to avoid posting it as bond. The contradiction isn't theoretical anymore. It's playing out in real time, with a looming 4-day deadline. And here's the tricky part. There's no credible defense that resolves both problems. Either Trump actually has the liquid assets he claims, in which case his court filings claiming inability to post bond are false and potentially sanctionable, or he doesn't have those assets, which means his campaign statements about his wealth were deceptive. Legal analysts see this as a situation where Trump's strategy of maintaining different narratives for different audiences has finally collapsed under intense judicial scrutiny. Legal and constitutional experts are calling this a watershed moment. Andrew Weissman, former FBI general counsel, told MSNBC that Judge Engoron's approach represents a crucial judicial response to what courts increasingly see as gamesmanship. He explained that when defendants have resources to file endless motions, judges eventually must draw bright lines. The hard deadline with immediate enforcement eliminates the incentive to keep filing delay motions. Joyce Vance, former U.S. attorney and University of Alabama law professor, told NBC News that courts operate on the assumption that parties will be truthful in their filings. When that assumption breaks down because public statements contradict sworn submissions, judges lose patience quickly. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Jonathan Turley, a George Washington University law professor who has frequently defended Trump, acknowledged the bond issue presents serious problems. He emphasized that once a judgment is entered and appeals are pending, courts have legitimate authority to insist on compliance with standard bonding practices. So, let's break down what this could mean. First, the immediate political impact is enormous. If Trump cannot post the bond by January 27th, the Attorney General will begin seizing assets. That likely starts with bank freezes and property liens. Properties like 40 Wall Street and Trump National Golf Club in Westchester could face liens. The visual of Trump properties being seized would absolutely dominate campaign coverage. Second, it creates undeniable credibility problems with voters. Polling by Morning Consult found that 61% of Trump's supporters believed his net worth exceeded $5 billion. If he cannot produce $464 million, that narrative collapses. Campaign ads are already being prepared with clips of Trump's wealth claims juxtaposed with news of seizures. Finally, Trump faces multiple other cases where he may need bonds during appeals. The Georgia RICO case almost certainly will. If judges in those cases see this pattern, they can point to Judge Engoron's ruling and say, "We've seen this before." Provide proof or face immediate enforcement. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate legal and political fallout, this is really about fundamental principles of equal justice. The American legal system operates on the premise that court orders apply equally regardless of wealth or status. Bond requirements exist to ensure defendants don't simply flee or hide assets while appeals proceed. If wealthy defendants can avoid posting bond by claiming their wealth is tied up in assets they're unwilling to liquidate, while less wealthy defendants sit in jail because they can't make bail, the system loses legitimacy. Judge Engoron's ruling powerfully reinforces that bond requirements aren't suggestions or starting points for negotiation. They're obligations backed by actual enforcement power. This scenario is reportedly causing absolute panic within Trump's inner circle. Sources told Rolling Stone that Trump's team has been making frantic calls to potential lenders over the weekend. Some advisors have suggested Trump sell a property to generate cash. Others argue that would be politically devastating. Meanwhile, Trump's core supporters are furious at Judge Engoron. Social media is flooded with claims this is political persecution. They're calling for protests and demanding Republican intervention. To the base, this proves the legal system is weaponized against Trump. Things escalated when Trump responded on Truth Social late Thursday. He called the deadline a complete joke and election interference. He claimed he had more cash than I need, but refused to reward a rigged system. Notably, utterly absent was any plan for actually posting the bond. Stay with me. Here's what makes the response even more revealing. Trump's post essentially confirmed what Judge Engoron accused him of doing. He claimed to have abundant cash while simultaneously saying he won't post it. That's a direct validation of the judge's analysis that Trump is choosing not to comply rather than being unable to comply. When your public response is, "I could do this, but I won't," you've effectively handed prosecutors the evidence they need. Barbara McQuaid, former U.S. attorney, tweeted that Trump's statement was essentially an admission of contempt. She explained that courts distinguish between defendants who genuinely cannot comply and defendants who simply refuse to comply. Trump's post made it clear he's in the latter category. This goes far beyond one bond requirement in one civil case. It's about whether the American legal system can enforce judgments against defendants who have resources to wage endless procedural warfare. If Trump successfully avoids posting this bond despite the court's final deadline, it signals that wealthy defendants can effectively ignore court orders by filing endless motions. That precedent affects every future case involving powerful defendants. If this blows your mind, hit that like button right now. Here's the situation. A federal judge has given Trump until Monday, January 27th at 5 p.m. to post $464 million or face immediate asset seizures. Trump's public statements claim he has the money, but refuses to post it. His court filings claim he cannot access sufficient liquid assets. The judge has made it clear that this fundamental contradiction is why he's imposing a hard deadline with immediate, undeniable consequences. Keep a close eye on this story. The New York Attorney General has reportedly targeted specific Trump properties for potential seizure. Legal teams are preparing enforcement actions that could be filed as soon as 5:01 p.m. on January 27th. Meanwhile, Trump's advisors are split on whether to sell assets or dare the court to follow through. Voters are watching with bated breath to see whether the legal system can actually hold Trump accountable. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. A federal judge just eliminated every escape route Trump's legal team had been using to delay posting a $464 million bond. He gave them until Monday at 5 p.m. to comply or face immediate asset seizures. Trump's response was to claim he has the money but won't post it, confirming exactly what the judge accused him of doing. Legal experts say this represents a judge finally drawing a line after months of contradictory claims and delay tactics. Meanwhile, the deadline is ticking down with no indication Trump plans to comply. This isn't just another news cycle that will fade away. This is a constitutional showdown unfolding in real time over whether court orders actually have teeth when defendants refuse to comply. What happens at 5 p.m. on Monday, January 27th, could determine whether the American legal system can enforce judgments against politically powerful defendants, or whether sufficient wealth and political support create practical immunity from court orders. The evidence is in the public record. The judge's deadline is explicit. The enforcement mechanisms are ready. Now we wait to see if judicial authority still carries any weight when confronted with a defendant who has made it clear he has no intention of voluntarily complying. The stakes have never been higher. The credibility gap has never been more obvious, and the constitutional crisis has never been more immediate. Pause for a second and hit that like button if you're finding value in this coverage.